everyone. Good afternoon. We are here today for the second in our three-part series of child custody webinars for advocates. The idea behind this series is not so much to make domestic violence advocates experts in family court custody cases, but more just to provide some background, some good information so that they are aware of what their client might be experiencing in family court, particularly if the client does not have an attorney, and how maybe they can help support, either just by trying to help them to get a little more familiar with what they're going to encounter, providing emotional support. There is so much involved in trying to pursue your own case, and you know, the support that an advocate can provide, even if it's not, you know, actual legal information and advice, can be really helpful. So the first, about a month ago, we did the first in the series, which was an introduction to family court, just kind of some of the players, the concepts, the legal principles that get involved, just to kind of get familiar with the terminology. The second one in the series is focused on evidence. So 10 steps for introducing evidence. And our speakers today are Judge Shaun Floerke from the District Court in Duluth, Minnesota, and Nancy Versteegh, who is a professor of law at Hamline School of Law also in Minnesota. One topic that always comes up whenever advocates encounter the court system is the repeated advice, or, you know, adage, you cannot give legal advice. You know, it's unauthorized practice of law, and you need to be very careful in how you phrase what you can tell people. And that is true. What you can do, though, is give information. And kind of a good way for understanding where that line is legal information is knowledge. It's knowledge of the law, court rules, court procedure, any other specialized information that somebody has through their education or their work or their experience. Legal advice is applying that knowledge to a client's specific case and telling the client what they should or shouldn't do. So for an example, legal information would be identifying the forms that can be used in a particular court, you know, on request, providing the form for requesting an exemption from mediation. If somebody wants to get a hearing before the judge, you can tell them the steps to do that, and that obviously is something more that court staff would do or a self-help center might do, as opposed to the advocate. But the advocate might know who to point them to for that information. Legal advice is telling somebody, well, you really need to get a hearing, and so you should request one. Or, okay, for this form, here's what you need to write for this spot. You know, in your case, this would be your best option. You know, you should go to mediation, or you shouldn't go to mediation, things like that. And so if you kind of keep that in mind, that should keep you from crossing the line into legal advice. And now at this point, I'm going to turn it over to Shaun and Nancy.
Hello, this is Nancy Versteegh, and I'll start us off here with a little bit of background information. We'd like you, for this presentation, to imagine that you are an unrepresented survivor, that you'll be representing yourself in court. We're going to walk through 10 steps designed to help you prepare your evidence. And Judge Floerke is going to be providing a judicial perspective on the importance of the steps and some other important tips that I think you will find really interesting. I should say, let me just say one more thing. I just want to say that this is really general information, and there are local variations. It's really important to check with your court or practitioner in your area before, you know, following everything literally. Did you have anything you wanted to add to that, Judge Floerke, or should we?
No, go ahead.
Okay.
Good. Welcome, everybody. Thanks for having us.
So just want to be clear from the start what we mean by the word evidence. Evidence is really just information that you provide to a judge who's deciding your case. We think of it in two basic categories. The first is testimony, which is information that you or someone else tells the judge. You might think of somebody on a witness stand doing that. The other kind of evidence that we'll be talking about are exhibits. They're things like email and text messages, documents, photos, and objects. These are more like things that you give to a judge.
And I think it's real easy. What we experience is folks kind of think about the exhibit parts of it, you know, cell phone records, text, video, CSI, all of that, and forget that the bulk of what we do is testimony. Folks coming in and telling what they saw, telling what they experienced. I think helping people be mindful of the two different, both testimony and exhibits, is helpful as you think about building a case, putting together a presentation.
The first of the 10 steps is learning what help might be available to you. It's best if you can find an attorney to represent you or give you advice about how to represent yourself. But of course, that sometimes doesn't happen for everybody. And if you can't find an attorney to represent you, it's a good idea to be aware of other resources. Chances are that your court's website will contain helpful forms and instructions. And your court may also have a self-help center, a place that you can actually visit and ask questions. Courts also have a clerk's office called the Clerk of Court office where you can ask questions and get information about court procedures. Of course, your local domestic violence advocacy program may also provide an advocate to support you through the process and help with safety planning.
Mm-hmm. Well, let me give a couple of examples. And I think you know, folks are pretty aware of or become aware of resources in their local area. You know, for instance, in our courthouse, we have a self-help center with a full-time lawyer. Fantastic help, fantastic resources. But before we had that, there was another self-help center in Minnesota, down in Minneapolis, that had a ton of information online, had people on the phone and in the office, and were available more broadly and willing to help. Our folks are willing to help too. You know, they'll answer the phone from anybody in Minnesota. So I think, you know, looking around and seeing what resources available more broadly but might still be available for you. Maybe there's also local attorneys in your community who practice family law or different types of law that would be able to be reference or help for the occasional phone call or the occasional run this idea by you. I think developing those networks and those resources can be really helpful in terms of preparing for court and getting ready for what might be coming your way. And I'd highlight what Nancy said too. The statewide websites can be really helpful. Some of them have video, mocks, things to show you, and for those of us who are visual learners, sometimes watching those things can be really helpful. So it's not always straightforward, but hunting for resources, I think, is a really valuable skill to learn and have.
Yeah. And just in the materials box, you'll see one of the PDFs there is 10 ways to find help with your case. That's a resource that we prepared that just has some ideas for places to call. It's got some ideas of things to check both nationally and to follow up locally to see what's available in your specific area. You know, one thing to keep in mind is family law and family court is almost exclusively state law based, and so it's different in each state. And that means, unfortunately, there's no easy way to do a big publication that has everything that you need to know. And so finding some good state and local resources and building a relationship, if possible, with somebody locally, an attorney who can, maybe be available to bounce questions off of, can be a huge, huge resource.
And here's another Resource Center on Domestic Violence website and phone number as well. So it's well worth it, I think, to check out the various resources that are available. The information you present to the judge depends heavily on the law of your state and what it is you want the judge to order. For example, if you want a protective order, the statute in your state will explain what you need to show and what the judge can actually provide. If you want custody of a child, your state law will tell you the factors the judge will consider and if there are any special laws that apply to cases involving domestic abuse.
Right. So, for us, the statute defines what I can do, what I can grant, assuming the proof is there. Asking me to do something I can't do is frustrating for everybody, right? Do you want X? I can't do X. So we've already started off on a kind of a clunky footing. So I think having in mind what the judge can do, and then secondly, what's the standard of proof? What do you have to show to get that? And there might be defined terms. You look at in order to get an order for protection or a civil restraining order or any other number of terms that states use for it, the criteria and what you have to show are different. Domestic abuse is a defined term under Minnesota law, and if you're using Nebraska's law, it's not going to fit. So understanding the terms, what they encompass, what kind of proof is needed, I think is really helpful. These things, hearings are can be so flooding and overwhelming that getting the legal rights and kind of starting off on the right legal footing where you're asking for something that the statute allows the judge to do, and you understand what proof and what defined terms mean, helps you get started well on the presentation, as opposed to maybe having huge communication errors on the front end.
And here's the address of an excellent example resource. And if you go to the womenslaw.org site, they have spent obviously a lot of time compiling links to all the states with the relevant statutory provisions that you may be interested in. So, of course, anytime you use information, it's great to check it with somebody locally, but this, I think, website does also provide some much-needed information that can help people get going. It's from the National Network to End Domestic Violence. Lots of state-specific information. On the third step, you are the best person to figure out what useful information or evidence exists to prove your case. In fact, you know more about your situation in your case than anybody else. So it's a good idea to think about people who could testify. This can include you. You are probably your very best and most important witness. But there may be other people who saw events or heard things. You may want to think about other people that could testify, like police officers, teachers, child care providers, even neighbors, relatives, and friends. You may have medical people, or once in a while, although you have to be very cautious about this, considering your child, hopefully a much older child, as a witness. But that's not something we recommend without some serious discussion with a family law professional. So there are people. Oh, go ahead. Do you want to talk about that for a minute?
Yeah, well, let me talk about people, or maybe I've
yes,
bumped
that's
into
fine.
Folks who've never been to court before will gather up letters from folks and say, Judge, here's a letter from my neighbor, or here's a letter from the daycare provider, or here's a letter from the teacher. I think it's important as you prepare to think about you need the witnesses there. People who see stuff and know stuff have to be there, and we'll talk about it as we go in terms of evidence that a judge can consider. But I think it's important for folks at the outset to think about who can you get there and who can testify. There are exceptions to the hearsay rule, but most unrepresented folks aren't going to have the wherewithal to start arguing about excited utterance or things like that. So I think thinking about having people there is really important.
And people may be very cooperative about coming,
right.
and eager to help and support you in that way. But you also sometimes, can rely upon your own testimony if there weren't others around or other people who could testify. So that's also really important to emphasize, I think.
Yeah, you're almost always going to be your first and most important witness. You're telling your story. You're telling what happened. Questions about were you harmed? Were you afraid? Things like that. Yeah.
And in addition to people who might come and testify, you may have some things to show the judge, some exhibits. And these can be a little bit more complicated to get them in the right form and ready to present, but they can be powerful forms of evidence as well. And these are things like photos of injuries or damage to property. You may have voicemail and recordings or videos of threatening messages. You may have various communications by email, text, Facebook posts, objects like broken furniture, weapons. You may have records from schools, medical providers, or some kind of police report.
One note on weapons, and we've had it. If you're planning to bring a weapon to court, it's best to call court security before you show up and kind of work that through as opposed to walking up with a knife in a bag or something like that. That alarms people, so just being aware of what's happening. We will get into more on how to present and turn these items into exhibits when we get further in here, but you have to be thinking about what all is there that can show what I need to show, what's going to matter, what's out there. I think, Nancy, you mentioned that a lot of people will be willing to come or willing to help. I think it's also important to know that you can subpoena people. You can bring folks in, perhaps even if they don't want to, or if they want to be able to come in and say, hey, I was forced to be here. That involves talking with court administration, figuring out how to do that. You have to get them served. There might be a fee. The fee might be waivable, but there is a way to bring in people who might be reluctant or who might want at least to be able to say that they aren't there voluntarily, that they had to come, that they had no choice. You often see that when there's kind of mutual relationships rolling around and folks are trying not to appear to favor one side or the other, but they still have something to say.
The subpoena can also help if somebody wants to come but needs a little nudge to get the time off of work.
Yeah.
There's a subpoena to show their boss that can often ease the way into letting them to be able to come. And really probably the biggest takeaway from some of what this is saying is there is help. I mean, there's means to get there. But it requires some planning and preparation and some advance thought. And that can be one of the biggest pieces of advice to give to your clients is, you can't just think about this the day before court. It will help you so much if you can be thinking about this, 2 months before your court date, or even just a few weeks. But it can really make the difference in how your presentation goes.
right? You can't come in on the day of trial and say, I want these witnesses here. You've got to work it up in advance. I think one other thing to point out is that, and we'll talk about what's relevant and what's reliable, what's persuasive as we get going, but Nancy listed teachers, police officers, often folks who are at least perceived as more neutral might be really helpful witnesses to call. They don't have a pre-existing stake or bias necessarily, and they can maybe come in and they might be perceived as more reliable than your best friend, for example. Your best friend might be a great witness and call them, certainly, but neutral third parties are pretty strong witnesses too sometimes.
So if we imagine that there's a lot of potential evidence that you might want to bring in, whether it's testimony or whether it's some kind of exhibit, but that doesn't mean you should bring all of it. And as we've been leading up to this in our discussion, you want to select the evidence that connects most directly with what you need to show. So a little example, if you're explaining to the judge how you were abused, information about your injuries will be really important, and it will be much more relevant to what the judge is deciding than something else, like how long you lived at your current address or how old your kids are or something. If you're really trying to prove that injury, you want to have some evidence that directly goes to that point. Now, you can use more than one piece of evidence to prove something. For example, in addition to your testimony, you may have pictures of your injuries, and you may have other testimony from people who saw or heard the abuse. The idea is to think about what you want the judge to order, and specifically what you have to show under state law to get it, and then figure out which evidence proves the points you need to make.
I think that people can make, and there's kind of two broad brush mistakes that can be made here. One is too broad a presentation, and what the judge will do, one way or the other, is try and narrow it down. Because what we're looking for is exactly as Nancy said, what's relevant, what's critical, what's on point. And folks have a tendency to be kind of nonlinear and want to tell the whole story, especially if it's an emotional, kind of fraught situation. That can sure happen. People get flooded and whatnot. I think having a chart, a sense of where you want to go and what you really need to prove can help kind of keep it on track. There's going to be times in a hearing where you're just knocked off track. Something comes up as a surprise, something gets heated, we go all legal language on you, and an ability to kind of have a sense of what's the key evidence and what do I need to talk about, what do I need to show, can be really helpful. I think it's also helpful to think about doing chronological discussion or chronological presentation, so that you kind of start and then you roll forward. Folks can jump around a lot, and it's not that it's not effective or a way to present. It's just really hard to follow because you find yourself trying to understand, oh, is this now, or is this 2 years ago, or was this the first car incident or the second? So an ability to kind of walk chronologically as you present, I think, is really helpful.
So as you're probably gathering, some evidence is better for our purposes than other evidence. And you want the judge to have the evidence that's the most trustworthy and reliable. So not only does it have to be on point and relevant, it needs to be something that the judge can legally as well as factually rely on. So with testimony, judges want to hear from people who actually saw and actually heard important events. That's going to be way more persuasive, it would be to any of us, than somebody, who heard about something later. You want people who actually saw, heard, and experienced. The same thing applies to exhibits. Judges need to know that papers and objects are what you say they are, that they're genuine, and that they're not made up by somebody.
Right. And it's just raw reliability. What's firsthand, what's truthful, what's legitimate. It's incredibly common to have folks say, "Here, Judge, I want you to read the police reports." And the word is hearsay typically. It's a statement offered for the truth by somebody who's not there. So maybe you need the police officers to talk about what they saw, what they heard. But if what you really want is the witness who talked to the police officer, who told the police officer X, Y, Z, then you got to get the witness in. The police report isn't going to do it either. And I get it. Folks have a police report and they say, "Here, read this." But our rules are that we've got to have the live people. And frankly, having a live person there telling you what they saw, what they heard, what they smelled, what they experienced is so much more powerful than reading through a secondhand report. That even in thinking about how you'd want to prove a case, you'd want the folks there, I think. We get a lot of, Nancy talked about, genuineness. We get a lot of stuff coming in now, as you might imagine, from social media, texts, emails, voicemails. You got to be able to tell people, this is X's voice. I know their voice. And sometimes when I'm listening to a tape, I can tell the voice too. Not all the time. But texts, whose phone number is that? How do you know? Emails, whose email? Whose Facebook? Whose, you got to be able to tie it to somebody who matters to the case. And there's often a fight over that. Somebody says, "Oh, those aren't my texts." Well, then we got to go deeper. I need to understand, how do you know these are the texts from that person? You just have to tie it together so that we know that it actually matters to this case, as opposed to just being a picture or an email or something that's kind of out of left field. And it doesn't have to be everybody thinks that it's got to be kind of these magic words, and I have to know that this matters to this case, and it is what it is. And with regards to emails or texts, give me the whole string. Give me the whole discussion so that I can see the context. I see a question about how do you prove that those are the texts. You talk about the phone number. This is their phone number, and this is the phone number we've gone back and forth on XYZ. And here's a discussion of going to pick up the 6-year-old from daycare, and we're talking back and forth, and we're talking about child support. So you can prove it through the phone number. You can prove it through the context. This stuff being said back and forth is clearly a conversation between two parents about a child. There's different ways to prove it up.
So as flows from what we've been saying, it's really important to consider how you're going to present exhibits in court, what you need to say and do. Courts have special rules, as we've been talking about, for making sure that exhibits are what they appear to be. The rules instruct you on the steps you need to go through to assure the judge that your exhibits are reliable and that they're worth considering. The judge will expect you to explain or demonstrate certain background information about exhibits, and we've already been talking about that in the last couple of minutes. You don't need to look at this now, but there is a handout that goes along with this presentation called 10 Steps for Presenting Evidence in Court. And there's an appendix on the back of it that lists the general steps you need to take to have a judge rely on the sorts of things we've been talking about, things like photographs, email messages, text messages, websites or social media, voicemail recordings, video recordings, handwritten notes or letters, objects, and records. The big key here is that you need to plan ahead to use these items.
I think the way that I see this done most effectively is if folks have a full set of what they're going to bring in, photos, texts, emails, everything, and they make 3 copies. One is theirs to hold on to so you can talk through it during the hearing. The other one is to give to the other side so the other side can see it. That's always going to happen, and the judge is always going to turn to the other side and say, do you have any objection to these exhibits? And then the third is the copy that would go to the court that's marked and that goes into evidence. And for me, it just seems really helpful to have that kind of level of organization, and that we're not handing photos back and forth and talking about this one, that one, and it just makes it much cleaner. These hearing, when you're presenting anything, anywhere, clarity can help a lot. So I think just thinking about how you're going to do it and making 3 copies really, really can help. If you're getting records from other sources, doctors' offices, courts, the Department of Motor Vehicles, things like that, you're going to want to get what's called certified copies, where whoever has that document is certifying that these are true and correct before you bring them to court. It can help you skip the step of needing somebody from that business to come and present it if you can. But I'd think about it. One of the questions that Amanda's throwing me is apps that allow someone to spoof their phone number, do different things without leaving much of a trace. How do you talk about that in court? Obviously, you want to do screenshots or some way to capture, because I'm only as good as what I can see. And then you'd need somebody who has the capacity to testify about what's going on there and why it's either legitimate or not legitimate. And it's got to be, it needs to be somebody who actually knows what they're talking about and can help the judge understand what's happening either through the app or through the technology. Not easily done, but you can't just ignore it. You got to figure out a way to actually talk about it. I think an ability to kind of think on your feet in court and talk about stuff, though really hard to get, can help a lot in terms of being able to explain to the judge, listen to objections, respond to what's coming at you. You need to be listening and kind of responding in the moment to what's happening. I agree, there's a lot of issues that come up through Messenger and all of the social media that we really are struggling with. But you got to do your best to explain it to us, and we got to do our best to try and understand.
Yeah. And it can come back to, what the judge was saying earlier about context. If this message makes sense in the context of, perhaps a conversation that started in a different media. For example, if the messenger call came, but before that there was a series of text messages. I mean, if through your testimony you can link that up and show how they had all flowed together, that should be able to help too. Right.
Here's a Snapchat from some number I don't know with a picture of a gun. The day before, I had a voicemail saying, "Watch out, bang." Years before, I was told if I ever leave, I'm going to be shot. Tying stuff together to present a coherent picture why it's more likely than not that this picture that came across from this unknown number might be related to what was said yesterday or the day before or the year before.
So here's an example.
Right.
I mentioned to you about Exhibit B, which goes through a number of different kinds of things you might want to use it as exhibits and gives you some directions about what you might do in terms of testimony or getting them in the right form to introduce them. So here's an example from that appendix just to give you an idea. If you wanted to introduce a printed paper photo showing something relevant to your case, your injury or some broken furniture, something that would go to a point you're trying to make. And the first thing you would do is ask the clerk of court, who will be clear who that person is in the courtroom, to mark the photo with an exhibit number. And they are ready and prepared to do that. And here's where the judge's tip about having 3 copies can pay off. Where you can give a copy of the photo to the other party and a copy of the photo to the judge. If you forget the copies, you can just hand it around to each of them, but you need to make sure to let them have a look at it.
Sure.
Then you explain that the exhibit is a photo and what's in that picture. And next explain that you were familiar with what is in the photo at the time of the relevant event that you're talking about. Next, you explain that the photo is a fair and accurate representation of the scene, person, whatever it is at the time of the event. And then ask the judge to admit the photo into evidence. And the judge will give the other party an opportunity to object if they want to, and will then make a decision about whether it comes into evidence. Then if it's admitted into evidence, that means the judge will consider it. But then you need to go on and testify about, explain how it supports what you're trying to show.
Right, right. This is a picture from St. Patty's Day with XYZ and the kids along drinking in a bar. Yeah, yeah. So you tie together what the picture shows and why it matters. Let me make a couple of points, and it's back to the 3 copies and exactly what Nancy's saying. You know, sometimes I'll have folks who bring in literally bags full of stuff and are incredibly disorganized, and I understand disorganization. I do, but it can be so kind of onerous to try and just sort through all of this stuff that you feel like you're losing traction in the hearing because it's just so disorganized. So any organization can help. And I think with this stuff we can focus. We've got meaning the court system has a way of doing this. We mark it, we offer it, we show that it's a accurate photo, that it's a fair and accurate representation. We can get stuck in the language. You have the right, if a judge says, I'm not going to let that in, or objection sustained, you can say, Judge, I don't understand. Can you explain that to me a little bit? I think you do it cautiously and respectfully. Don't roll your eyes. But sometimes there can be a pretty easily solved reason or something that you can do that then would get the photo in. I'm trying to think of it. You know, let's say it's an intersection. Well, there's snow on the ground here, and it wasn't snowing that day. Well, Judge, I'm not trying to show the snow. I'm trying to show where the lights are. And the lights are exactly where they were the day before when it wasn't snowing. You know, so there's ways to kind of ask questions and be in the moment and try and fix some stuff. And I think people can have a fear, a frustration tolerance, and just kind of bail on it when you've got a exhibit that's become frustrating or hard to get in. But remember that it's okay to ask, I don't understand that ruling. Can you tell me what you mean by that? I ought to be able to say in pretty easily accessible language what the problem is with an exhibit if I'm either objecting to it or if I'm keeping it out.
We've talked about this step a little bit already. But the importance of getting together the evidence that you're going to present. And of course, how much you're able to do of this depends on your time frame and what you're trying to show. Your testimony, of course, will undoubtedly be critical, and you may have other witnesses. We talked already a little bit about the subpoena process, that if there's somebody or something you need that you can't get, or that you need help compelling, that you can go to the clerk of court's office and ask them to help you subpoena people or items. And you should inquire at that point, you know, how that process is going to work, what's your involvement in it, is it going to cost money, those kinds of questions.
Yeah, I don't have a ton to add. I would add a piece, you know, and Nancy was mentioned early on that you can use multiple exhibits to prove a point or several points, and you can use multiple witnesses to prove points as well. At some point, if you're bringing in the third or fourth or fifth person to tell me about what person 1, 2, and 3 and you already told me about, I'm going to want to not hear more. Repetition can become irrelevant and kind of slow it down. So at some point, you'll need to decide in terms of gathering the evidence you're going to present is who's your best, who's your strongest. Do you need 10 people to talk about what color the light was?
Just quickly, we had a question about certified copies, and I answered it in the chat, but just so everyone can hear. You get the certified copies from the entity that made the document. So if it's from a doctor's office, you'd get it from the doctor. If it's from, you know, some state agency, you get it from the state agency. And there may be a charge for that. So just know that going in, and there may be some lead time needed. Some places can do a very quick turnaround. Some places might need, you know, a few days or even a week or so. And so, again, the advanced planning comes in there.
And if your DMV is like the Minnesota DMV, they're going to need a lot more time than that.
So as you can see, it's important to prepare exhibits ahead of time. And in the appendix, there's, I said, information for the general steps you want to take about how to prepare and present exhibits. So you want to think about things like, is your exhibit in the right form? Sometimes, like email messages, you need to print them out. It may be there are different ways that you might present a recording. One way is to have it typed out. You might need to take screenshots of some media. You might need to bring a thumb drive with something on it, or we've already talked a little bit about certified copies. But in Appendix B, there's some very general information to help you think about getting your exhibit into a form so that it can be admitted into evidence and stay with the court. You also want to think about what copies or other information you need to provide to the other party ahead of time. We've talked about how many copies to make, typically 2 copies and an original. And think about who, other than you, may need to testify in order to have your exhibits considered.
Right. If it was a voicemail on somebody else's phone, they may need to be there to talk about the voicemail, how it came in, who it's from, things like that. We struggle with this all the time. Folks say, Judge, here, look at my phone, or Judge, here, can I play the voicemail? I think it's helpful for people to think about when we take exhibits into evidence, we got to keep them, and I can't keep your phone. So it's got to be in a format that I can keep and that can go up on appeal and that everybody can look at and all of that. So it involves, you know, being able to burn it down to a WAV file or something like that. Talk to court administration well in advance and find out what the courthouse has in terms of technology, what they'll accept, what they'll keep, what they'll use. A lot of the hurdles can be overcome by a little bit of advanced preparation and conversation.
The next step has to do with organizing your presentation. And we've talked a little bit about this, but you'll feel a lot more confident in the courtroom if you're organized. Lawyers like to make a notebook, called a trial notebook or hearing notebook, that has various things in it. And you can do something like that, although however you organize yourself, it should be in a way that makes sense to you. But think about what it is you want the judge to order. You may want to write that down. What you need to prove in order to get that relief. It's very helpful to have a list of witnesses, mostly in the order you're going to call them. You want to have some notes probably about the points each witness is going to testify, and that includes you. You want to have a list of your exhibits that you want to introduce and some idea of or written down version of the procedures that you'll have to go through to have your exhibits accepted by the judge. Think of, for example, of the example we just talked about with a photograph. You might want to have those steps written down so you can just go boom, boom, boom right through them. And it's very useful to have a summary of your major points because you may have a chance at the end to tell the judge what those are.
And then for witnesses too, you know, a list of questions you want to ask, or even just a note about the what the information that this witness has that you want to be sure to get out. And if you're comfortable with coming up with questions on the spot, then you might not need to write yourself out a script. But although that can be helpful, particularly if you think you're going to be nervous and you just want to have something, that can be useful. But otherwise, just know, okay, I need to get this witness to tell about a particular incident or to tell about what happened with the child care pickup that day. And that way you'll be sure that the big pieces of evidence that you really need come in.
Right, just kind of echo that. Again, with the point of chronological is helpful. And the hearings are fluid, they're real time, they can be heated, they can be stressful. I think having this kind of organization and notes, and when I was trying cases and had witnesses, I would put down the 4 or 5 points that I had to have out of that witness. I didn't prepare questions per se, but before I said no further questions, I looked at my list and made sure I'd crossed everything off the list, that I'd covered what I needed to cover with that witness, because you're going to be in and out, and it's hard to keep track. So I think having some level of organization is really helpful for everybody.
Finally, if you have the opportunity, it's a really good idea to go to court and observe a hearing, preferably a hearing that's being done by a judge who may be hearing your case. That's not always possible. But you want to pay attention to some things so that you're more comfortable on the day of your hearing. You can see where the parties sit, typically at the front of the courtroom at counsel table, but at separate tables. You can hear the instructions that are given by court staff. You can watch people address the judge, typically as Your Honor. You can see whether most parties are standing up when talking to the judge. That can be different in different courtrooms. You can see how witnesses are called and how you'll call your witnesses to the stand. You can watch those witnesses being sworn in. It's important when testifying to be making eye contact and eye contact with the judge as you are talking to the judge. You can see how people ask questions and how people ask questions of the other party's witnesses. That's called cross-examination. You can watch people putting exhibits into evidence and how they go through the steps. And you can see what happens when someone objects to a piece of evidence, saying that it is not perhaps what the person says it is.
Yeah, this is fantastic advice, and it's on the one hand easy to do because we have hearings constantly. I mean, there are 9 judges in my building, and you can walk in. We do, for instance, order for protection hearings every single week, a dozen or more, or harassment hearings or family motions. So it involves taking some time off. I get that. But I think this can be a really valuable tool. One, in terms of everything Nancy said, being aware and prepared when you go in on your hearing on how much of this is going to flow, so you've got some grounding in how it happens and what's going to happen. Even the sense of how long do these hearings tend to take, how much time do I have. I think on a human level and a kind of a people level, it helps take the edge off a little bit too. It's not that completely unknown, fearful, stressful experience. I get it's still stressful. It's still tough, but you've seen it. You know, when I was litigating cases, I would go in and I'd take witnesses in. We'd sit and watch hearings. We'd watch trials. We'd find lots of different ways to try to get people aware of and somewhat accustomed to what they were going through. I see a question on the chat. Can you go to the court website to see a list of hearings? You certainly can here in our jurisdiction and in many jurisdictions, yeah. So you could even look on the website and try and find hearings that were the same as yours so that you could watch them. But I'd say even if you can't, say you were coming in on an order for protection hearing, even if you can't watch an order for protection hearing, go watch a harassment hearing, go watch a family motion, go watch something, because it'll help take some of the edge off, familiarize yourself a little bit, and then you'll get a sense of how the system works around there and how hearings go. I think it can be really, really valuable.
Yeah. And just not all courts will have their hearing schedule posted online, but if that's not the case in your court, you should be able to get that information by calling the clerk's office, and
right.
They'll be able to tell you if there's hearings scheduled, at a particular time, and that can be really helpful. And it can also, even just in addition to the experience of watching the hearing itself, sometimes it can be good to know, okay, here's where the parking is. Here's how long I can expect it to take me to get through security. Even if you can't get in to watch a hearing before the judge that you'll be seeing, you'll be able to find out where that courtroom is. And right. that is just fewer things to stress out on the day of the hearing itself.
Right. I'd say a couple other points too. Pay attention to security and what they're doing. Know where they are, know where they aren't, see what their rules are. They can be incredibly helpful folks. Also, staff. What are courtroom staff doing, or advocacy staff, or other folks in the building? Just paying attention and seeing just the dynamics of what's going on, I think, can help a ton.
So I encourage you to take a look at the handout on the 10 steps for presenting evidence in court, in particular the appendix that has examples of some of the more technical aspects of introducing exhibits. Remember, these are general, and your jurisdiction may do something a little bit differently. But one of the key points is that, and I know it can be intimidating to think about doing this, but most of the technical aspects of introducing evidence are things that you can deal with ahead of time by planning and be prepared for. And doing that work ahead of time will make you feel much better on the day of the hearing and, of course, increase the likelihood that all of that evidence will be considered. And remember, courts have these rules about evidence so that judges will make decisions based on good information and not on gossip and not on guesswork. And so the rules are there actually to protect your rights. And they can also be a great guide for you in planning your court appearance. Any other comments, Judge?
Yeah, I was about to say, Judge Floerke, if you want to take that question.
Yeah, we've had 2 questions about subpoenas and therapy notes. The way I handle it is nobody gets therapy notes until I say so directly, that has to come to me. It's not a subpoena that you deliver therapy notes to somebody's office or somebody's house or whatever. It would be a therapist or their entity demanding, really, or one of the lawyers or parties demanding that the judge review that subpoena and make specific findings and decision about whether those go out. I think that's absolutely consistent with Minnesota law. I can't talk about other legal communities, but that's how I do it. They don't go out until I say so specifically.
Yeah, my experience has been that that the notes don't come in. That the therapist may testify, but the notes are not put in the record.
Well, and I was even talking about release to parties, let alone put in the record.
Right. Okay, well, I think we're about out of time here. One last quick question. Where would a client find online about doing a restraining order? The best first place to look would be the particular court where the client is, because that will be specific information based on that jurisdiction. But there is a lot of information on, for example, womenslaw.org that was in the presentation earlier. You can look up that state and it will have information about protection and restraining orders. That's probably a good first place to look. I'd like to thank our speakers, Judge Floerke and Professor Steegh. So thank you so much for being with us. A recording of this webinar will be available on our website, rcdvcpc.org, within a few days or a week at most. We also ask you to complete the evaluation, and if you do, then and you need a certificate of attendance, you will receive one at the end of the evaluation. And if you have other questions, please feel free to call or email the Resource Center, and we'll be happy to help you however we can. Thanks again.
Thanks, everyone.
Bye.